Say again? Okay. Sounds good. You got backup, Mr. Gordon? Yeah, yeah. She's joining us online. He's just saying. Don't turn your back, brother. Don't want to turn you back. Mr. Wareham, could you do me a favor and close that door, please? Hit the switch that says off on. Yep. Thank you. Yes, like most things in government, a little slow. Good morning, committee. Welcome back from the weekend. I'm hoping that everyone has enjoyed that great weather. We will now call ourselves to order. And let's see, I want to start off by taking any requests for bill introductions. Do we have any requests for bill introductions? From the gallery? Seeing none. Any from the members? Seeing none. Okay. That said, let's get into Senate Bill 77. Today we're going to do a hearing, and Mr. Gordon or Ms. Natalie, who is joining us via WebEx, could you please clue us in on Senate Bill 77?
Thank you, Mr. Chairperson and members of the committee. I'm Gordon Self, Reviser of Statutes. Senate Bill 77 passed the Senate without amendment and came over to the House and was referred to your committee. And it's a bill that deals with rules and regs in two aspects. It was requested by the Secretary of State's office over in the Senate. One, the first part of the bill is prior to revoking rules and regs, the state agency needs to provide written notice to businesses, local governmental units, members of the public known to the agency to be affected by the proposed revocation. The second part of the bill provides that there's a requirement that every 5 years an agency has to review a rule and regulation, and it lists out a timetable schedule for it, and the bill simply removes abolished or inactive agencies from the list. When the list was made, it was made from a list of agencies, and over time the Secretary of State's office in conjunction with the Revisor's office reviewed that list and pinpointed inactive agencies and abolished agencies, and so simply those agencies are taken from the list of agencies that are required to review. There's, like I said, in Section 2, there's a timetable that sets up each year which agencies are to submit their written report as to the status of rules and regs that they had promulgated. The first part of the bill I'll just go and speak a little bit more on, and then I'll let the Secretary of State's office describe the background behind the change. But there is a requirement in law that talks about, we're simply talking about revocation of rules and regs right now. And this requirement requires that each state agency has to give notice to the entity, local governmental units, et cetera, that is known to that agency to be affected by that rule and reg. So that notice is given with regard to the public hearing on the revocation of that rule and reg.
Well, thank you for that rundown. Mr. Self, we always appreciate the fine fashion in which you and your team come in and let us know exactly what these bills are talking about. I'd like to open up the committee for any questions that you might have of the Revisor's office. Representative Riley.
Thank you, Mr. Chair. So, looking at the different departments and everything, can you explain what the definition is, or how it comes around, whether something is a department, a board, a committee, a commission, and the importance maybe of each one of those, because it's all over the board here of the different ones. Some of them have nothing, some of them have stuff. So I'm looking at the State Board of Mortuary Arts. Well, is that a commission? Is that a board? So can you give us a definition of those different agencies?
Yes, I don't know that I can give you a definition, but I can tell you that as the legislature creates the different administrative entities, let's use that, creates the different administrative entities that are going to deal with administration of laws that affect a certain subject area, when they create that entity, they make decisions. The legislature at that time makes a decision whether it's going to be a traditional state agency or whether it's going to be a board, you know, where members are appointed to that board, and that board is assigned that subject matter, or whether, you know, we're going to set up a commission. But the legislature at the time that the enacting legislation is created goes through that. Often they rely on the subject matter experts who are recommending that we need administrative body in that case, and they often recommend the form in which that is eventually enacted.
And Rep. Riley, for your follow-up, please.
Thank you, Mr. Chair. So again, a follow-up, going back to that specific one, there's several like this, but, you know, there just seems to be a lot of inconsistency as far as when they made these kind of things. And so what you're saying is this is a lot of history of how these were all developed, kind of thing. And so sometimes there's no, you know, actual saying that this is a department. So is there anything that the revisor's office, as we go through this, could make some kind of a definition of what a department is, what a commission is, what any of this kind of stuff, or is that just such a common term people don't know? I mean, don't make any difference.
I think one of the most basic, first of all, we could go through and provide some more specificity for you, but to a great extent, it's, like I said, the advocates for the need for an administrative agency often come forward and suggest the form. Probably the most basic is if it's within a state, if they want it to be clearly within a state agency and create a state agency, versus they want some some outside interaction as well. Some of these boards, especially, the boards are made up of members of the public that represent either the general public, or they represent, you know, organizations that have a specialty in that area. And so the goal is, instead of it having it embedded in the traditional sense within a state agency, we want that half step, you know, to include members of the public or organizations, but yet still have the administrative responsibility and duties and authority that it would be encompassed in a traditional state agency. And it's a case-by-case analysis.
Thank you for that. Representative Oropesa.
Thank you, Mr. Chair. Thank you for your explanation. I have a question in regards to, is there a definition of written notice? I didn't see one in the bill.
No, there's not.
Okay, I have a follow-up question, Mr. Chair. Thank you very much. And then I wanted to clarification on how is this different from the status quo that you currently said that we already had?
Well, there's no, on revocation, there's no requirement to give notice to interested parties of a hearing to revoke. And so what this is doing is trying to, the agency which knows best, and I'll let the Secretary of State's office talk to you about how this issue came up and why they decided to come forward with it. But the state agency would be the best entity to know who might be affected by the revocation of this regulation.
Okay, thank you.
Representative Howerton.
Thank you, Mr. Chair. So we had a bill earlier this session where we're renaming the insurance department. Is that going to affect this at all? Because it just says insurance department, I'm assuming.
I haven't read that legislation, but typically when we rename an entity, we also go out in that bill and we find statutes and we make an attempt to update them along with the bill. And then often there's catch-all language that says, anywhere it says this, it says that. I mean, there is an aspect that this list should periodically be cleaned up, but at the same time, I think the interpretation would be in the terms of the insurance department, even though the name may not be exactly right, they still are under obligation under this statute to review their regs according to this schedule.
Perfect, thank you.
Representative Joji?
I guess mine's sort of a question in the form of a statement. My interpretation of this, thank you, Mr. Chairman, is it's any administrative agency that makes or interprets rules or regulations will report to a committee periodically so that the legislature can evaluate if that is the intent of the legislature and it can be dealt with whether whatever way it needs to be. Is that too far off?
No, that's a good interpretation.
Representative Simmons?
Thank you, Mr. Chair. How does this bill relate, if it relates to the recent sandbox bill on agencies and sandboxes and regulations going to different heads?
Well, with regard to the reporting requirement, it really wouldn't have direct effect. With regard to the revocation requirement, there could be some interaction between the two, but I'd have to review the sandbox bill in its specificity to determine how the two would interact. This is, to a great extent, I don't want to overplay this. This bill is, I hesitate to say the word technical, but this bill is certainly Section 2 that deals with the updating of the state agencies is technical in nature, but even Section 1 with regard to this is just simply a notice requirement that would fall in a technical, more technical, or certainly just trying to take care of a problem that exists with regard to notice of hearings, and it's not in a major substantive way.
Thank you very much.
Okay. No, you're fine. We got you. Representative Turner, please, for the first time. I didn't know if you were asking me if you wanted to.
See, I was just looking for the language that makes the second part happen. So this removal and abolishment of inactive agencies, I see where they've lined through them. That makes it work for now, but is there language that allows that to be an ongoing?
What'll happen, the lines mean that those words will be removed from the statute, and so that agency or that abolished or inactive agency will no longer be on the list, which is the effectiveness of it. A statement would not be needed since the language removes them from the requirement.
But going forward, if others become inactive or abolished, then we'll have to just go in and line them out and do this again, right?
We would. Now, obviously, like I said, this is to, a technical part of bill clearly, because if you do have an abolished or inactive agency, they're not doing anything. And so they're not enacting new regs that would need to be evaluated. Part of the issue, and I'm going to let the secretary, I don't want to steal your fun, but, part of it was some of these inactive and abolished agencies, there still were rules and regs on the books. And to, from a legal standpoint, they would not be effective, and yet there's a question out there. And so this is an important cleanup, but as to the future, yeah, I think this is something the Secretary of State's office will be keeping apprised of, and if there's needed additional amendments and cleanup, they'll contact us just like they did this time, and we may be standing here again in front of you to clean this statute up.
Okay, thank you. Thank you, Mr. Chair.
Okay. Do we have any other questions from the committee? Seeing none, thank you, Mr. Self, for helping us out with those questions and running through the bill. And at this time, I'd like to call, I'm looking at the list of who we have for testimony today. I'd like to open up proponent testimony and have oral proponent testimony, as well as is written in your S-Drive from Mr. Clay Barker, who is the Deputy Secretary of State. Did I get the title right?
So, Mr. Chair.
Yes, sir. Please state your name and title so I'm not messing it up.
Clay Barker, General Counsel for the Kansas Secretary of State, and we brought SB 77 on behalf of all state agencies who are involved with regulations. And just a quick background, unlike statutes where the revisor is in charge of it, it's all online, you can track bills and know where they are. There is no agency in charge of regulations unless Ms. Temple's able to get our new online system through. The only way you can figure out where a regulation is in the process is to call the agency and ask them if they happen to know. But getting onto this particular bill, as background, in 2022, the legislature enacted the 5-year review process for regulations. And the way that was set up is it took all 116 agencies from the table of contents of the Kansas regulations, broke them into 5 groups, about 20 agencies for each year, and the first group would review all its regulations and would have to submit a statement and answer a lot of questions about them, what statute authorized it, or is this a federal requirement, but have to say, we need this regulation as is. That statute also created a new tool for agencies called expedited revocation or expedited repeal of a regulation. Before that, to get rid of a regulation, it was just as hard to write one as it was to get rid of it. It took a long time. The first group went through in 2023, and I think luckily that group included the Secretary of State, Attorney General, and the Department of Administration, which includes the Department of Budget, which are the 4 agencies that have the biggest role when a regulation goes through the process and then it ends up in front of JCAR in a public hearing. And these agencies noticed a weakness in the statute, and that was that the expedited repeal said essentially if the public gives you notice, you have to provide a hearing. But it didn't give a standard for how the agency gives notice to the public for the public to again give notice to the agency. And agencies were hesitant to use the expedited repeal because of that. So in 2024, we saw the first outcome of the 5-year review. The first group's process went through, and we saw actually a spike in amended and repealed regulations. Because when you force an agency to sign off saying, yes, this is good the way it is, they'll change it to make sure it's good. We also brought in 2024 a bill, this exact bill, to the House, passed 120 to 0. Well, I should say one word different. House passed it 120 to 0. The Senate amended it with one word, Senator Francisco, 40 to 0. Went to conference committee last year, and it got, I think the polite term is repurposed for a different subject. So we're bringing it back, the identical bill. It got through the Senate 40-0. And the 2 pieces to this bill, one, it puts in some language. It just creates a standard for the notice an agency must give that it wants to expeditiously revoke a regulation. And the language may seem a little generic. It just says written. And we pass this around to multiple agencies. And every agency has a different public that it needs to communicate with. It could be trade groups. It could be individuals. It could be county clerks. So written, the way we interpret it in the broader sense is email, website, anything that's written that you can look at. And that way the agency's lawyers can say, yes, our agency's notice meets the statutory requirement, and then agencies will be much more willing to use expedited repeal to get rid of regulations faster. And as the revisor said, we did find some agencies, for instance, one was abolished in, I think, 2002, but the way the bill was written is it then later told that no longer exists an agency to get rid of its regulations, but because there was no agency, there was no one to get rid of the regulations. They've been sitting there for 25 years. And when we did this process, I just told the system, just get rid of them. Even though there is no agency to do it, obviously we don't need them anymore. And I think there's a lot of good cleanup coming out of this review. And then, Representative Turner, to answer your question, we would not have brought a bill just to get rid of outdated agencies. And of the 116, 19 no longer exist, and one was essentially in there twice. It had changed names and jurisdiction, but it was listed twice. But as long as we were trying to fix the expedited repeal, we thought we'd just get rid of these 19 agencies. But if an agency's, there's a provision for new agencies to be added to this list. If an agency no longer exists, there's nothing it can do. And Representative, to answer your question, I don't know the difference between a board and a commission either. That's why we always use the generic term agency or department and commission board. I think part of that may just be historical. Whatever the legislature named it is the name it has. I don't think it has a functional difference, except the department may have a secretary from the governor. And with that, Mr. Chair, I'll end my testimony. But again, I think it was correct to say this is somewhat of a technical bill, but the real focus was to create a standard so agencies can expeditiously revoke regulations and have the confidence that they know what the legislature's standard is to put out notice. And with that, I'll stand for any questions.
Fantastic. Representative Riley.
Thank you, Clay, for leading right into my question. So is the Secretary of State an office, a commission? So should it say Office of the Secretary of State? Because right now on your thing, it's just the Secretary of State. So it could be a department.
Representative, the way I understand it is the Secretary of State is a constitutional office, and it's the Secretary of State. So we're not a department under the governor. We don't have like a Secretary of Labor works for the governor, Secretary of State, and the Attorney General are independently elected constitutional officers, and the Treasurer and Insurance Commissioner. So you have a Commissioner, a Treasurer, a Secretary, and a General. So it's by statute.
Representative Weichel.
Thank you, Mr. Chair, and thank you, Mr. Barker, for being here. I do appreciate the inclusion of the public notice. My question is around a timeline. So it doesn't seem to specify like if they need to give notice for 30 days, 60 days, 90 days. Like what is there an intent there, or did you guys have discussions about that? Like how long the public notice must be there?
I remember we discussed it a little bit and decided to leave it up to each agency, and I guess I shouldn't say trust, but the agency would have to send out notice. So for instance, if we were doing, our office was doing an election regulation, we'd send it to all the county clerks and say, we plan to get rid of this regulation. Does anyone have a comment? And the hearing could be a in-person hearing, it could be online. We left that up to the agencies also, because we had so much input. Some agencies are large, that have thousands of regulations, like KDHE. Some may only have one or two, may have 2 people on staff. So I realize the language is somewhat generic, and there is no timeline in there also, but that was because there was so much different input. We tried to get the common denominator. And when I say we, again, the Secretary of State is not responsible for regulations. We just picked up the flag and decided to bring this bill to the legislature, and all the other agencies were supportive of it, just nobody wanted to volunteer to do the work.
And I'm so sorry, but Mr. Self, you said you wanted to jump in on a piece of that discussion. Go ahead, please.
Yes, with regard, part of it, Clay is correct. The language is generic, but the current statute does say that the revocation of the rule will not be effective until 15 days following publish of the notice in the register of the revocation. So there is a time frame in there with regard to the actual revocation can't occur until the notice is.
Please follow on.
Yeah, thank you, Mr. Chair, and thank you. I did see that. It just seemed like 15, I mean, I know we're talking about expedited revocation, but that seems quite expedited. So I was just wondering if the intent was that there would be a longer period of time for people to receive notice of the possible revocation and be able to request the hearing and have some input on that.
Would you care to speak to that, Mr. Barker?
Representative, there is no timeline in the bill. It was just a requirement that the agencies send out notice, and I guess the underlying assumption is that it's a rule of reasonableness. It depends on the audience. Some audiences could respond in a day, whether anyone thinks this regulation serves a purpose. Others may need a longer time period. But we essentially left that up to the agency when we were drafting this language.
And I think that term, the reasonableness, is probably the governing piece there, both for the notification that it will be revoked, but also the time frame in which it actually occurs. Representative Turner, please.
Thank you, Mr. Chair. See, I was thinking about this language and what we're obligating ourselves to in terms of notification and the potential for someone to say, we didn't get notified. But it's a best efforts, if I understand the wording. It's you're checking with those agencies and they're giving you who they believe. So it says known to the agency. Is that, so it's a best efforts, and there may be an outlier that could say, hey, you didn't notify me, but it's not a blanket obligation. Is that fair?
That's correct, Representative, because essentially the agency first has to decide this regulation no longer serves any purpose, any public benefit, but then it has to give notice to the affected community, and that could vary quite a bit. We were visiting other government agencies, trade groups that could then tell their members just to see if anyone has an objection to getting rid of the regulation. It's another underlying assumption is an agency won't get rid of a regulation unless it really no longer serves a purpose.
But if someone raises their hand and say, hey, you didn't notify me, the answer is we weren't advised that you were a likely user of that particular regulation by the agency.
Correct. And right now, Mr. Chair, if I could, when a regulation gets adopted, there's a public hearing, and I would say the overwhelming majority, no one shows up for the hearing. And then occasionally you'll have one, sometimes election ones, where the room is triple packed with people because activists get it out to the community. And these are all on our website. We do post all the hearing notices. Some people follow them. Some lobbyists will attend just to watch to see if anyone shows up. But if the public cares, they'll show up. But usually no one shows up to hearings.
I appreciate the explanation. Thank you, Mr.
Thank you so much, Representative Turner. Mr. Self, please.
And keep in mind, under the Kansas Open Meetings Act, notice is only required to be given to parties that request notice. So this standard is the agency's going to make an attempt to identify interested parties and give notice.
Thank you for that. Chair recognizes Representative Esau.
Thank you, Mr. Chair. I think I have two, and I think they're both short. But I'd also point out that on this page 2 under C, that the joint committee gets notice, and if they have a concern, the chair can call a meeting to look at it if we thought they were getting rid of a rule or reg that we thought was really important for some reason. I would think most of the time the public would be cheering we got rid of a rule and reg, but maybe not always. And now I'm trying to remember what my other question was because I've been listening to intently. Oh, I know what it was. The good senator from Douglas, did we leave in her change so that she won't need to change it again? Because I heard that the bill was the same as last time and that there was only one amendment that got made on the Senate and then we lost it. But maybe this bill is totally different from that one?
Representative, this bill it's one word different from what the House approved last year, and it includes the one-word Senate amendment from Senator Francisco. So when it went through the Senate this time, it was 40-0. 40-0 was the vote.
Okay, thank you. I just wanted to make sure so she wouldn't catch that again.
And thank you for that. Both you and Representative Turner have been asking all of my questions, so I'm at a loss here. Representative Oropeza, please.
Thank you, Mr. Chair. So then I was piggybacking off of Representative Turner's question. So in regards to making the list, that does not come from the Secretary of State, correct? It's driven by the agency.
Correct, Representative. Whenever the legislature passes legislation on regulations, there's usually meetings of the Attorney General, Department of Administration, Department of Budget, Secretary of State, and we go through it and try to adapt our current process to the new statute. And we all work together, and this was a common suggestion, and we asked many agencies around the state if they had any concerns with it or supported it, and there was universal support for fixing the notice provision. So an agency would know what its standard is for notice.
Thank you. So in regards, I'm talking specifically about the list of businesses, businesses, local government entities that would be potentially affected by revocation. So that would come from the agency and not necessarily from the Secretary of State.
I'm sorry. Yes, absolutely correct. Each agency knows its own public for each type of regulation. Like, again, for us, an election regulation would go to county election officers because that's who we're regulating. Other agencies, it may be trade organizations or particular lobbyists that represent organizations, or if they have a membership list, and then, again, as the revisor stated, because it's a hearing, an open meeting, it would have to be posted or given to people who have asked for notice. And our website has that tool. You can ask for the regulations coming from certain agencies and getting notice of that.
And one more,
Please.
one more, sorry. When you mentioned website, it made me think of another question. And for those who do not have technology, broadband, what are their options? Is that for every agency to decide?
That would be up to every agency, but right now in the hearing process to adopt a regulation, there's no real provision for like newspaper ads or anything like that, or letters. It's all online and email.
Okay, thank you.
And forgive me, Representative Oropeza, are you getting at the concept that there should be some type of universal standard, if you will, on how this is promulgated out to the public?
I think we're just missing potentially a big portion of the population that does not have access to technology, broadband, basic internet, website, those types of things. I think we're potentially missing a big portion of the state.
And the bill, as it's currently written, is silent on how that's actually dictated by the agency when they publicize that. Is that correct? So we leave it agnostic. We leave it up to them to choose how they do that?
Mr. Chairman, that's correct. I will indicate from, and I am more familiar with the process that relates to open meetings and requests there. Typically, when an agency receives a request from an individual to be notified of a public hearing, the agency gives the notice in the form that the requester submitted their request. So, for example, if someone submitted a letter for a request, typically the agency will respond, by letter. If they submit an email, the agency will give notice to that individual requesting notice by email. I would assume in this case, not dealing with when they're creating their own list of affected interested parties, but if they do know of people that have requested notice, they'll give notice in that same format. So an agency may be giving notice in multiple formats.
Thank you for that, Mr. Self, and we'll let Mr. Barker weigh in on it, and then we'll go to Rep. Riley.
And again, Representative, so there's the standard requirement that if someone has asked for notice of a hearing, they get that notice. This puts an additional affirmative burden on the agency that if they're going to revoke, they have to let everyone they're aware of would be interested in that revocation know about it. So it's an extra duty that doesn't exist for most hearings.
Representative Riley.
So since you know of this personally, does the Secretary of State have such a list of people that want notices of rent? If a bill gets or if a regulation get revoked, do you have that already? That a list of those people that you send out, other than lobbyists or whatever?
Yes, Representative. Our website, just because we're the publisher of regulations, not really the manager of it, has a tool where someone can say, I want notice of any regulations, amendments, new, revoked for particular agencies. And they can just check that off and they'll get it automatically. Email, the agency will send it out to them. Or they can get on our website. We're sort of the tool that people can go to. It'll list public hearings, how to give input to hearings, things like that. A lot of people aren't aware of that, but we try to publicize it, that we have that tool on our website, and that Ms. Temple, that's her area.
I was about to call Ms. Temple up. You've invoked her twice. I don't know. Maybe she wants to speak in defense of herself. Committee, do we have any other questions for the General Counsel for the Secretary of State's office, Mr. Clay Barker? Seeing none, Mr. Barker, I want to thank you for your testimony here today. I appreciate that.
Thank you, Mr. Chair. Thank you, Committee.
Committee, I have in the S drive, we have the proponent testimony from Mr. Barker. You can take a look at that as well. I have no other proponents that are written. Do we have any other individuals who want to provide proponent testimony orally here today? Anyone in the gallery would like to be a proponent? Seeing none, I'm going to close proponent testimony and open up neutral testimony. Do we have anyone in the gallery who'd like to provide neutral testimony? We have no neutral testimony from the gallery. We have none in the folder that is written. So I'll close neutral testimony and open opponent testimony. Do we have any individuals in the gallery who would like to provide opponent testimony orally today? Seeing none, again, going back to the S drive to our file folder, we have no opponent testimony in the written form either, so I will close opponent testimony. And after that, committee, we will close the hearing on SB 77. Look forward to working this bill at a later date, and we'll notify you when that happens. Right now, I don't think that we have any other business before the committee. I would like to remind everyone that today is Aviation Day for lunch. If we're off of the floor, actually, I don't know if we have a lot going on today, but from 12 to 1 on the first floor south wing, all legislators are invited. No RSVP is necessary for the Kansas Association of Airports doing Aviation Day. Do we have anything else for the good of the body? Seeing none, we are adjourned.